Good day, ma'am. Good day, everyone. So, I am Christopher ADVINCULA, and today I will discuss the chapter 3 in this subject, which is the legal aspect and tourism and hospitality. So, in this module or chapter, we will be able to discuss the law of obligations and contracts, as well as the importance of contracts of every establishment, as well as applying contracts in our industry, which is the tourism and hospitality industry. We will tackle about the law connecting to obligations and contracts, as well as the different consequence or punishments when the establishment fail to follow the contracts. So the learning objectives: identify the different kind of obligations and contract, enumerate the ways of extinguishing an obligation, enumerate possible application of contracts in tourism, travel, and hospitality industry. So for the contents, we will discuss the different law and obligations, as well as the classification of obligation, mode of extinguishing obligation, as well as we will discuss about the contract and the classification of contracts. So law. So we all know that contract is connected to law. Law applies to contracts. So if the establishment didn't do the responsibility as what the contract agreed by both parties, the tendency will be the law may judge the consequences. So the law. So a person desiring to engage in a business in the tourism, travel, and hospitality industry will meet certain obligations, agreements arising to contracts. So part of contract is the agreement. Contract is applicable especially in business industry. So in tourism and hospitality industry has also a contract. So in the Article 1156, an obligation is a judicial necessity to give, to do, or not to do. So in this article, an obligation just necessity is to give or to do. The term obligation is to derive from the word obligatio, which means tying or binding. It is tie, so which binds a person to render something to another that may consist in giving a thing, doing and so it talks about maybe partner in the business or in the industry. So the obligation is a legal duty, however created, the violation of which may become the basis of an action of law. So every obligation has four definite elements without which no obligation can exist too. So the first one is an active subject, also known as the obliged or creditor, who has the power to demand the prestation. The second one is the passive subject, so also known as the debtor, who is bound to perform the prestation. The third one is an object or the prestation, which is an object or undertaking to give, to do, or not to do. So the fourth one is the juridical or legal tie, the vinculum which binds the contracting parties. The juridical tie or vinculum is based on the sources of obligation arising from either the law or the contract. So for obligations of the passive subject, so there are two parts of the obligation: to determinating, and the second one is to obligate to do. So first, the obligation to give I determinating. So to deliver the thing which he has obliged himself to give, to take care of the thing with the proper diligence of a good father of a family, to deliver all its accessories and accessions, to pay damages in case of breach of obligation. For the obligations to do, so if the debtor fails to do what is obliged to do, it will be done at his expense. So it's more on obligation to do, so it's more on the penalty if the debtor will not do their part or the responsibility in the business or in partnership. The second one is if the work is done in contravention of the debtor of the obligation, it will be redone at debtor expense. So debtor expense, so So third one is if the work is poorly done, it will redone the debtor expense. So in this area, so it tackles about the debt if the debtor will not do the responsibility. So the tendency will he or she have an expense or penalty. So the sources of liability. So the first one is the fraud or dolo incidenti, which is fraud incident to the performance of the obligation. So in fraud, there is an intent to evade the normal fulfillment of the obligation and to cause damage. So dolo incidente or accidental fraud, which is referred in the Article 1344, are those which are not serious in character and without with other party will still have entered into the contract. C is dolo fault or negligence. So felonies are committed not only by means of deceit or dolo, but also by means of fault, which is culpa. So there is deceit when the act is performed with deliberate intent, and there is fault when the wrongful act results for imprudence, negligence, lack of foresight, or lack of skills. So the second one is the negligence. So it is referred in the case of contracts is culpa contractual the lack of diligence or carelessness. So negligence consists in the omission of that diligence which is required by the nature of the obligation and corresponds with the circumstances of the persons or the time and of the place. So the third one is the delay or mora. So delay. The debtor can be held liable for a delay or default in the fulfillment of his obligation. So when the debtor will do a delay action, so it will cause of expense maybe. So as may depend judicial or social on other debtor, except so when the law expressly provides the demand is not necessary, when the contract expressly stipulates that demand is not necessary, when time is of the essence, when demand would be useless. So next is the contravention of the tenor of the obligation. So violation of the terms and conditions stipulated in the obligation. So the praise in any manner contravene the tenor of the obligation in Art 1170 or the Civil Code includes any illicit task which impairs the strict and faithful fulfillment of the obligation or every kind of defective performance. So next is the passengers do not contract merely for transportation. So in the law article 1157, obligation arise from first law is a part of the 1987 Constitution. The second one is the contracts, a meeting of minds between two persons whereby one binds himself with respect to the other to give something or to render some service. So contract is involves two or more people. Or the best example is the partnership in the business. So quasi-contracts, it refers to the lawful, voluntary, and unilateral act based on the maxim that no one shall unjustly enrich himself at the expense of another. So the fourth one is the acts of omission, so punishable by law. So this act is for connected to the law. So quasi-delicts, also called a culpa aquilana, is any act or omission which cause damage to another, there being fault or negligence and there being no persisting contractual relation between the parties. So we will proceed in the classification obligation. The first one is the primary and the second one is the secondary. So for primary classification obligation under the Civil Code, pure unconditional obligation in the article 1179 to 1192. So these obligations are immediately demandable while conditional obligation depend on the occurrence or non-occurrence of uncertain event. So obligation with a period of article 1193 and 1198 from the word period, so it's all about specification of the time frame. So there is specification of date, as well as the specification of time when or where that the responsibility will be finished. Next is the alternative, which is 9119 and 1205, and facultative obligation in the Article 1206. So alternative obligation offer multiple ways of fulfillment, while facultative obligations allow for the substitution of a different performance. The fourth one is the joint and solidarity obligation in the Article 1207 to 1222. So this obligation, it requires two or more debtors, and solidarity is the opposite of joint of obligation, which means only debtor to fulfill the obligation. Next is the divisible and indivisible obligation in the Article 9, 1223 and 12225. An divisible obligation can be partially performed, while indivisible obligation must be fulfilled entirely. So we talk about divisible obligation is all about partial, so not totally, but an indivisible, so it means totally obligation. So next is obligation with a penal clause, Articles 1226 to 1230. So this obligation is all about the rising of penalty in case of non-fulfillment. So next will be the secondary classification of obligation under the Civil Code. So unilateral and a bilateral obligation. So if we talk about unilateral obligation, it involves one party without any involving any party. So, and bilateral is opposite to the unilateral. So this obligation entail both parties and having a mutual obligation to each other. So the example of business for the unilateral obligation is the sole proprietorship, which is there is only one involved in the business. For the bilateral, the example of this is the business is the partnership, which there are two or more parties involved in the business. Next is real and personal obligation in the Article 1163 and 1168. So real obligations are those that involve the delivery of a specific object, while personal obligations are based on the performance of act by the debtor. Next is the civil and natural obligation in the Article 1423. Civil organizations are enforceable by law and arise from agreements or contract, while natural obligations are moral or ethical obligations that do not have legal enforcements but may have moral implications. So for the legal, conventional, and penal obligation, the Article 1157, 1159, and 1161. So legal obligation arise from law or statutes. Conventional obligation arise from agreements or contract. So legal, so it talks about there is involvement of the law, while the stat conventional obligation is all about the agreement or the contracts between parties, and penal obligations involve obligation with penalty attached for the non-fulfillments. So next is the mode of extinguishing obligations. In the Article 1231, obligations are extinguished by payment or performance. So fulfilling the obligation by paying or performing. So if you talk about payment, so it involves the money, and if the performance is all about the actions or the um, service rendered by the customers or either the partnership in the business. Next is by the loss of the thing due. So if the object of the obligation is lost, the obligation is extinguished. Next, by the condonation or remission of the debt. So if the creditor forgives or waives the debt owed by the debtor. Next, by the confusion or merger of the rights of the creditor and debtor. So when the rights of the creditor and debtor are combined, such as through inheritance. Next is by compensation, and when the two persons in their own right are creditors and debtors of each other, the debts are extinguished up to the amount of the smaller debt. Next is by novation, other cause of extinguishment of obligations such as annulment, rescission, fulfillment of resolutory condition, and prescription are governed always in this code 11568. So when the parties to an obligation agree to substitute a new obligation for extinguishing one. So there are other causes of extinguishment of obligation which are not expressly provided under the above provision. So death extinguishes the obligation which are purely personal in character, such as partnership and agency. Obligation may also be extinguished by the happenings of a fortuitous event or by will of one of the parties, as in some contracts such as partnership and the agency. So what is fortuitous event? So this event is something unexpected happenings often resulting in a positive outcome. So fortuitous event may be produced by two general causes, which are the nature such as earthquakes, storms, floods, epidemics, and tsunamis. So a fortuitous event can be classified also in a natural disaster. So next is by the act of man such as armed invasions or the attack by bandits, governmental provisions, or others. So if talk about for choose event, so this means that these are the unexpected happenings in the society. So next is the contract. So Article 191305, a contract is meeting of minds between two persons whereby one binds himself with respect to other to give something to render some service. So I'll know that contract is consists of two or more people will give something to render more service. So what is the purpose of the contract? Contract is for helping one another in doing a business or any other concerns about. So a contract is an agreement between parties creating mutual obligations that are enforceable by law. The main purpose of a contract is to formalize new relationship and outline the various legal obligations each party owes to the other. So the essential elements of contract are as follows. So first, consent, which is manifested by the meeting of the minds of offer and the acceptance upon the thing and the cost which are the constitute the contract. So the offer must be certain and the acceptance obsolete. Next is object certain, which is the subject matter and the contract, and the last one is the cause of obligation, which is established. So let's now move on the characteristic of contracts. So mutuality of contracts, this refers to the principle that for a contract to be valid, both parties must agree to the same terms and conditions. So in contract, there will be a terms and condition or responsibility to do of the both parties. So in other words, there must be a meeting of the minds between two parties involved. Next is the autonomy of contracts. So this principle emphasizes the freedom of individuals or entities to enter into agreements on your own terms without interference from external parties as long as the terms are legal and not against public policy. So for the relatively of contracts, so contracts are considered relative to the parties involved under particular circumstances. So this means that what might be a fair contract between two parties may not be fair in different contexts. Next one is the consensuality of contracts. So this principle highlights that contracts are formed through mutual agreements or consent of other parties involved. So both parties must voluntarily agree to the term of contracts without coercion of jurors. So it means nga dili ra mo sa ang mag-decide so ang parts sa partnership. So obligatory force of contracts. So once a contract is formed and the parties have agreed to its terms, it carries legal obligations that must be fulfilled by both parties. So this means that if one party fails to fulfill their obligations, the other party may seek legal remedies. So next will be the classification of contracts. So according to the relation of other contracts, so according to their perfection, according to their form and according to their purpose, according to their subject form, according to the nature, according to their costs, as well as according to the risk involved, and according to their name. So, so according to the relations to other contracts, so contracts can be classified based on how they relate to other contracts, such as whether they are independent contracts or dependent on another contracts. So for according to their perfection, so this contract can be categorized based on their stage of completion, such as executed contracts fully performed, executory contract which yet to be performed, and void contract not legally enforceable. So for according to their form, so contracts can be classified based on their formality, such as formal contracts that require specific formalities like writings. And informal contracts can be oral or amplified. So for the formal contracts, so there part of this is papers or documents that states for the responsibility and duty of the partners. For the informal, so it can be oral agreements. For the according to their purpose, so contracts can be categorized based on their intended purpose, such as contracts for sale, lease, employment, and others matter. So for according to subject matter, contracts can be classified based on what they deal with, such as contracts for goods, services, real estate. And for the according to the nature, contracts can be categorized based on their inherent nature, such as contracts of adhesion, one party dictates terms, or contracts of mutual consent, parties negotiate terms. So according to their cause, contract can be classified based on their underlying reason or purpose, such as contract based on sale, gift, or lease. For the according to the risk involved, contracts can be categorized based on the level of risk each party assumes, such as fixed price contracts or cost reimbursable contracts. For the according to their names, contracts can be classified based on their specific names or titles, such as lease agreements, purchase contracts, service agreements. So that's it for today for the contracts. So to sum up all the discussion, um, contract is very important if we talk about business, especially if focus in the hospitality and tourism industry. So contract can be determine um, identify the responsibility of duties um, of one person as well as and partnership. So that's all for today. Thank you and God bless.